The issue to be settled in this appeal is whether the land trial judge was right to have convicted the appellant of a lesser offense which he was not charged with, after discharging him of the offense that he was charged with. 1. Mr. Mohammad was arraigned at the High Court of Delta State for the offenses of conspiracy to commit armed robbery and armed robbery, contrary to Section 6 Paragraph B, and punishable under Section 1 Subsection 2, Paragraph A, of the Robbery and Firearms Special Provisions Act. After he pleaded not guilty to the charge, the prosecution was called to prove his guilt. The prosecution called 4 witnesses and tendered 10 exhibits in proof of his case, while Mr. Mohammad testified in his defense and did not call any other witness. At the conclusion of trial, the learned trial judge found that the prosecution failed to prove the offenses of conspiracy and armed robbery against Mr. Mohammad. Instead of to discharge and acquit Mr. Mohammad, the trial judge proceeded and found that the evidence before the court revealed clearly that Mr. Mohammad was found in possession of tricycles, which were robbed from PW1 and PW2, and that Mr. Mohammad failed to explain how he came about the robbed tricycles. Thus, the court found him guilty of the offense of receiving robbed property and accordingly sentenced him to life imprisonment with hard labor. Dissatisfied with the decision of the trial court, Mr. Mohammad appealed to the Court of Appeal, Asaba Division. The legal issue set for determination at this appeal is whether the trial court was right in convicting the appellant, Mr. Mohammad, of the offense of receiving robbed property, even though it was not part of the offenses he was charged with, but was convicted on it after the charges of conspiracy and armed robbery with which he was charged failed. In arguing this issue, the learned Silk, who represented the appellant, noted that the evidence presented by the prosecution at the trial was based on the offenses of conspiracy and armed robbery, and did not lead any evidence to establish the offense of receiving robbed property. He submitted that the conditions for the invocation of Section 179 of the Criminal Procedure Law to convict the appellant Mr. Mohammad for the lesser offense of receiving robbed property were not present in the case. He also argued that the element of conspiracy and armed robbery are not the same with that of receiving robbed property, and therefore urged the Court of Appeal to set aside the decision of the trial court. He also noted that the learned trial judge convicted Mr. Mohammad of a lesser offense of receiving robbed property, solely on the doctrine of recent possession, under Section 167 Paragraph A of the Evidence Act. The learned Silk submitted that Mr. Mohammad gave explanation of how he came about the tricycles and that the trial court does not need to be convinced of the truth to displace the presumption of recent possession. He added that the explanation only needs to be weighed on a balance of probability and has to be reasonable to discharge the owners. He further noted that the explanation given by Mr. Mohammad at the trial court was not challenged by the prosecution and therefore urged the Court of Appeal to hold that the trial court was wrong to have concluded that Mr. Mohammad did not give any explanation as to how he came into possession of the tricycles. He also urged the court to hold that the trial court was wrong to have relied on Exhibit B as a confessional statement in convicting Mr. Mohammad because there was nothing in Exhibit B to support the conclusion that Mr. Mohammad had knowledge that the tricycles were proceeds of armed robbery. In response, the prosecution, who was the respondent at the appeal, contended that the trial court was right in holding that the prosecution has proved the offense of receiving robbed property beyond reasonable doubt against Mr. Mohammad. He argued that Mr. Mohammad was aware that the tricycles were proceeds of armed robbery and that he played active role in taking possession of it, and even wanted to sell them off. He also argued that the explanation he gave before the trial court as per how the tricycles were in his possession did not satisfy the requirements of the law. He submitted that the common ingredient between the offense of robbery and the offense of receiving robbed property is that the goods are stolen and that the accused must have been in possession of them. He equally submitted that Mr. Mohammad admitted the crime in Exhibit B and urged the court to hold that Exhibit B is confessional in nature. To resolve the issue, the Court of Appeal listed 5 grounds to convict someone for lesser offense under Section 179 subsection 1 of the Criminal Procedure Law of Delta State. 1. The ingredient of the lesser offense must be subsumed in the main offense. 2. The circumstance under which the lesser offense was committed must be similar to that of the main offense. 3. The lesser offense must be an offense under the law or act under which the main offense was charged. 4. The evidence led to prove the main offense must be sufficient to prove the lesser offense. 5. It is not necessary that the accused person must be charged with the lesser offense to be convicted on it. The court also set out the ingredients of conspiracy, which includes that 1. There was an agreement between two or more persons to carry out an unlawful act. 2. The two or more persons took steps to carry out the unlawful act. 3. Each of the persons actively participated in the doing of the unlawful act. The court also reproduced the ingredients of armed robbery thus: 1. That there was a robbery or series of robberies. 2. That each robbery was an armed robbery. 3. That the appellant was one of those who took part in the armed robbery or robberies. The element of receiving stolen or robbed property was also reproduced thus: 1. That the goods were stolen or robbed. 2. That the accused person must have been found in possession of the stolen goods. 3. That the possession must have been soon after the theft. 4. The accused person is unable to account for his possession of the goods. The court then found that there is no element of the offense of receiving robbed property that is subsumed in the ingredients of the offense of conspiracy. The court also found that there is only one element of receiving robbed property that is subsumed in the ingredients of armed robbery, which is that there is robbery or theft with violence. The court then held that this itself cannot constitute the offense of receiving stolen or robbed property. The court then held that contrary to the argument of the respondent counsel, possession of stolen property is not an element of armed robbery. The court further held that the argument of respondent's counsel that the appellant, Mr. Mohammad, confessed to robbing the tricycles, and that having been found to be in possession of them, he was guilty of receiving stolen property is difficult to digest, because one cannot steal a property and at the same time be said to have received the same as a stolen property. Finally, the court held that one condition for the invocation of Section 179 subsection 1 of the Criminal Procedure Law was absent in this matter, and that his conviction for the lesser offense was like a bolt from the blue. The court held that the conviction is nothing but judicial ambushment and a breach of the appellant's fundamental right to fair hearing as guaranteed under Section 36 subsection 6 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. The court also held that the general position of the law is that where a breach of the right to fair hearing is established, it affects the proceedings, thereby rendering the decision of the trial court null and void. The court therefore entered a negative answer for the issue for determination and resolved same in favor of the appellant, Mr. Mohammad. The judgment of the trial court was set aside and Mr. Mohammad was duly discharged and acquitted.